Yes, welcome back, friends. And here is the news actually, and what it says, only PepsiCo can use Mountain Dew trademark rules, High Court. So if you really want to view the original, you can go and look at here. I am using a app called Pocket. So here I am able to see those properly. So let's go to the point. So on behalf of PepsiCo senior counsel so and so, Mr. Vivek Reddy argued that the firm had registered Mountain Dew trademark in 1985. It stated that McFast Beverages had dishonestly copied the name. This is the image description. Let's see the case now. Hyderabad, the Telangana High Court made it clear that PepsiCo has exclusive rights over Mountain Dew trademark. So, city-based McFast Beverages is marketing packaged drinking water bottles with the Mountain Dew name. Okay, so let's see further. PepsiCo had sued the firm in the city civil court. Okay, 18 years back. The dispute reached the High Court as both companies were aggrieved by lower court's orders. Okay, so they went to the High Court as both the firms did not argue with that. The trial court had held that PepsiCo's rights over Mountain Dew were not exclusive and that McFast Beverages also had a right to use the trademark because it was the first to use the label. So this is very important. It says that it was first to use the label, that is why they had a right. The court reasoned that while Pepsi was using Mountain Dew trademark for soft drinks, and it was not, I doubt whether it is still using that. McFast was using it for bottled water, and these were two different categories. So under this, actually, McFast actually won the case. It was a news 2 years back, 2020. So we also have covered a video on this with almost half an hour video, which exclusively discusses the case type by type with a trademark expert. So you can see that in the card above. So it was claiming that two different categories it was. So it is in plain words, PepsiCo was into not into bottled water with this mark, and McFast was using this for bottled water, that is packaged drinking water. The trial court also observed that the rights conferred by registration of the trademark were subject to right of prior users of the trademark, which in case was McFast Beverages. So McFast Beverages were the first to use the trademark for packaged drinking water. So later on, PepsiCo approached the High Court by stating that they were already spending good amount of money, 15 million per annum, on the advertisement and promotion of Mountain Dew, whose global annual sale was approximately $7 billion. In contrast, rival firm, that is McFast Beverages, has sales of just rupees 3.25 lakhs. So in other words, PepsiCo was claiming that they were spending on advertisements and they were also making good amount of money. So it's a huge sell, and this firm was not at all. On behalf of PepsiCo, senior counsel K. Vivek Reddy argued that the firm had registered the Mountain Dew trademark in 1985. It stated that McFast Beverages has dishonestly copied the name for selling bottled water. So in short, they wanted to say that the similar water name was dishonestly used by them. So they wanted to take the disadvantage of the water brand. So senior counsel Mr. Sunil B. Ganu, representing McFast Beverages, argued that his client was not aware of PepsiCo's trademark and that it came up with Mountain Dew brand on its own 2000, much before PepsiCo launched soft drinks in India. That is what they say, that before launching soft drinks in India, it was owned 2000. Okay, so the High Court bench, comprising Justice P. Navin Rao and Justice G. Radharani, held that PepsiCo had exclusive rights over Mountain Dew as it had a valid registration since 1985. So it is not 2000 as it claimed. It was registered in 1985. The High Court noted that Mountain Dew enjoyed worldwide reputation, which is a fact, even before 2000, when the drinking water brand was launched by the city firm. Okay. Now this is very important, which I have highlighted. The court held that even though bottled water and soft drinks are different products, they are sold across the same counter. That is very important. It is beverages. And if they are sold by an identical mark, customers are likely to believe that both are being sold by Pepsi, which sounds to be logically correct in this case. Here I also want to make a point that there is an opportunity for all the newcomers who wish to enter into packaged drinking water. What you can do is you can also introduce similar strategy like Pepsi. You can start with aerated water, which does not need ISI license. Understand this. Packaged drinking water needs ISI license and huge facilities like that. So you can start with an FSSI license with soft drinks, and later once your soft drink is established like Pepsi, you can get the water also. You can get it done from somebody else with co-packing, or you can also start your own thing. So this is just a side point which I want to mention. So the bench held that McFast Beverages had committed copyright violation by copying the Aquafina label and the description on Aquafina's bottle. I was searching for Aquafina, not Aquafina, but McFast label somewhere on the internet, but I was not getting it. But it says that it has exactly copied the description of Aquafina label. Okay, so McFast is the name of the brand, and Aquafina label information is actually copied. That is what they say, which is the bottled water brand of Pepsico. The High Court issued a permanent injunction barring McFast Beverages from infringing on PepsiCo's trademark, and also directed it to pay rupees 5 lakh damages to PepsiCo. So this is the case, and on which we also, I just had told you that we are also done a video on this. So also refer to that. The link is here itself on top in the cards. And if you want to see the original article, you can just check this particular link here, or you can just go and you may find this case on the internet also. So in Deccan Chronicle latest, this is the news. It can be in many magazines actually today. So this is the news. Anyway, so let's draw the conclusions from it. What conclusions we can draw from this? So the learnings from this particular case study is, first is always file a trademark. Okay, this is number one. Before filing a trademark, go to the search if existing. Okay, take a help of a proper trademark consultant. So now there are many people available, company secretaries also do it, but check it that they have a proper knowledge of trademark things. That is intellectual property. Okay, so check if existing. This is second. Third is yes, you can do first. You can do start with this aerated beverages. Aerated, 1 minute, my spelling is wrong. Aerated beverages. What is aerated beverages? Aerated beverages is colas, or you can also see carbonated beverages. So these actually plants can be started in lesser capital and lesser hindrances. So this you can always start, and later on you can launch your packaged drinking water. Later, PDW I am mentioning here. Okay, and if that too, if you have a tight budget, lesser budget, you can start with co-packing kind of thing. So co-packing also we have got several, we have got a playlist only. You can start with co-packing. Packing for small budgets. So you can start a co-packing business in as low as 5 to 10 lakhs to 25 lakhs maximum. Okay, you don't need IS and all that. So just refer the playlists, so you'll get that. And also one more point here to notice, to know about the segments. What are the segments you have to go to? Like in Pepsi's case, they have said that on the same counter packaged drinking waters are sold. So segments you can understand from one more video we have here for business model canvas. Okay, so just go to the business model canvas video also, that will help you. Okay, so this is all about the learnings. Always feel free to comment here or visit our website. In the description the website thing is given. So do follow that. Thank you so much.